Okay, so let's wait for them to be here first. Later on, when it times to take the attendance, I will call up based on group to group basis because this is three tutorial T5, T9, and T3. Right. So if we're supposed to have I think around 50, more than 50, 60 students by right. Okay, can I see how many of you is from T5? Can you please raise the hand button first? T5, 7. Okay, okay, 8. All right. Okay, lower your hand, please. Zihao, lower your hand first. All right. Can I see how many of you is from T9? Anyone here from T9? Okay, no one here is from T9. Anyone from T3? Okay, we have 10 from T3. Later on, when it times to mark the attendance, because I have to take your attendance manually, right? This is how we are going to do it. I'm going to call up according to the group because I need to update via 2 pages in your CAMSIS. So it's going to be a bit time consuming. Okay, lower your hand. T3. Again, anyone here from T9? Okay, no one here is from T9. Okay, no issues. Okay, maybe the class on 3 to 5 is still on. Worry not. Okay. For the rest of you, today's class we're going to discuss two different tutorials. The first one is on the fraud and mistrap, and immediately after we're done with this, we are going to look uh, the second tutorial, that is mistake. All right. So without any further ado, let us take a look at all the questions that we're going to discuss today. For fraud and mistrap, we have 4 questions. The first one is about discussion of 2 cases, Tan Chai Chu and another Aniston Mining and Metals Company Limited, and also the case of Weber and Brown. Okay, second question is a situational question. Okay, on 2 issues. The first one is on the representation that Bashir told Abu that the space could easily accommodate 100 cars, while instead it could only take 60. And second one is on the issue that Bashir never disclosed that the land is going to be compulsorily acquired by the government. So you have to discuss on these two representation. Third question is on the mere silent, as silent is not fraud. And fourth question is about the burden of proof required in civil cases. Okay, burden of proof in cases of fraud in civil proceeding. So these are the four questions that we're going to discuss today. Can we discuss now, class? All right. Okay, for the first question, uh, read the following cases: Tan Chai Chiu and another Eastern Mining and Metals Company Limited, and also the case of Weber and Brown. Okay, both cases is listed under the exception to section 19. Right? So anyone is kind enough to help me attempt the first question? Sivashini, thank you so much.
So we have to discuss the case of Tan Chai Chiu and another, and Eastern Mining and Metals Co. Limited. So the story of the case is like this. The respondent entered into two separate contracts in this case. One with the first appellant for the assignment of rights for certain mining land included in an approved prospecting permit application. And the second contract is with the second appellant for the payment of commission for the second appellant's role to bring about the first contract. So the second appellant was accused of showing respondents' geologist some land that was later revealed not to be included in the authorized application. So the trial court found that the second appellant had knowingly shown the erroneous region with the knowledge of the first appellant, that the second appellant was guilty of fraud, and that because the second appellant was the first appellant's agent, the first appellant was accountable. So the appellants took issue with the trial judge decision. The court held that a high standard of proof is required in cases where fraud is alleged. So in this case, there was insufficient evidence to support the finding of fraud against either appellant, and consequently, there can be no rescission of the ground of fraud, and the award of damages for fraud should be set aside. Sir, should I discuss the second case also?
Yes, please.
Okay. So second case is about Weber and Brown. So the story of this case is like this. The plaintiff respondent sued the defendant appellant for damages in respect of an alleged false and fraudulent misrep relating to the number of rubber trees on an estate over which the latter had the right of purchase, which right he transferred for valuable consideration to the former. So can you hear me?
Yes, I can hear you loud and clear.
Okay. The number of trees represented was in excess of the number which actually existed on the estate. So the Court of Appeal agreed with the finding of the lower court that the defendant appellant had made that alleged misrep falsely and fraudulently, and it had caused the plaintiff respondent to acquire and subsequently to exercise the right of purchase. So the court held that the appellant's statement that he had counted the trees on the estate and his action of writing the number of trees on a paper, which he handed to the respondent, amounted to fraud. So the court also held that the exception in Section 19 did not apply to cases where the misrep is by a false and fraudulent assertion, as was established in the instant case. That's all, sir. Thank you.
All right. Thank you so much, Sivashini. All right. So, class, these two cases, Tan Chai Chiu and Eastern Mining Metal Company Limited, and also the case of Weber and Brown, discuss on the exception to Section 19. He discussed on the exception to Section 19. If such consent was caused by misrepresentation or by silent, fraudulent within the meaning of Section 17, the contract nevertheless is not voidable. if the party whose consent was so caused had the means of discovering the truth with ordinary diligence. So these two cases discuss on the determination what amounts to ordinary diligence. Okay, for example, in the case of Weber and Brown, okay, because it was stated that the trees has been counted, well, in fact, the amount listed, advertised is higher than the actual amount that is available on the land. Or in the case of Tan Tai Chiu, okay, because the court held that the respondent had the means of discovering the truth with ordinary diligence. Why? Because the respondent had facilities to ascertain the position of the land and had 4 days to do so before signing the contract, but they did not do so. So this is what court determined within the definition of the or using ordinary diligence. So whether uh, this ordinary diligence, what is the actual definition, okay, is being taken by the court on case to case basis. Okay, if it is something that is not too hard, for example, like the case of Gemuk Kota Sendirian Berhad, okay, hiring to hire the service of someone else prior to making a bid, okay, is considered to be something that is uh, outside of ordinary diligence. All right, we clear, class, for the first question? Class, yes, all right, thank you. Okay, moving on to the second question. Abu purchased a plot of land from Bashir for the purpose of opening a car park. During the negotiation, Bashir told Abu that the space could easily accommodate 100 cars if properly placed. After the purchase was concluded, Abu found out that the space was small and could take in 60 cars only. 2 weeks later, Abu received a notice from the government that one half of the land would be compulsorily acquired for the widening of the existing road. Bashir did not disclose this matter during the negotiation. Had Abu known this, he would have not concluded the agreement. Abu now seeks to rescind the contract and claim compensation, alleging Bashir had fraudulently misrepresented the facts to him at the time of entering into the sale and purchase contract, advised Abu. All right, so this question, there are two issues. Okay, of course, the main issue is whether Abu can rescind the contract and claim compensation from Bashir. Okay, however, there are two main issues. The first one is on the representation made by Bashir that the space could easily accommodate 100 cars, while in fact it could only take in 60. And second one is when Bashir never revealed the fact that the government is planning to compulsorily acquiring half of the land for the purpose of widening the existing road. So you're going to discuss these two issues, whether they amount to misrep, whether they amount to fraud, whether the exception to Section 19 is applicable. All right. Anyone would like to try and attempt this question? Lakshana, thank you, Lakshana.
Yeah, I say I can try and I'm not sure correct or not.
No, it's okay. It's okay. This is the purpose of why we have the tutorial in the first place. What? No issue.
Okay. So my first issue is whether Bashir had fraudulently misrepresented the facts of the plot of land to Abu. And then my law is Section 18 of the Contracts Act has laid out the definition of misrepresentation. In Section 18 of Contracts Act 1950, a misrepresentation comprises the positive assertion in a manner not warranted by the information of the person making it of that is not true despite him believing it to be true. Additionally, misrepresentation also includes the breach of duty which, without an intent to deceive, gives an advantage to the person committing it or anyone claiming under him by misleading another to his prejudice or to the prejudice of anyone claiming under him, and causing, however innocently, a party to the agreement to make a mistake as to the substance of the thing which is the subject of the agreement. Also, in the case of Chua Tonyong and Kuala Lumpur Golf Country Club Sdn Bhd, the requirements in order to prove misrepresentation can be referred into, whereby the defendant in this case was a developer and manager of a golf, golf and club, golf and country club. They published a brochure which listed out the facilities and features of the club, golf and club country, And some of the facilities available were 100 covered car parks and 500 open car parks. The plaintiff paid 9,000 to become a member of the club. However, the plaintiff found that some of the listed facilities were non-existent. Consequently, the plaintiff filed a declaration of complaint against the defendant and subsequently sought a declaration of annulment of his membership. The return of 9,000 he paid along with damages. So, applying the prison case, Abu purchased a plot of land from Bashir for the purpose of opening a car. And Bashir told Abu that the space could easily accommodate 100 cars, while in fact it was just 60. Abu also received a notice from the government that one half of the land would be needed for the widening of the existing road, in which Bashir did not disclose such matter during the negotiation. First, there are two parts coming to this, in particularly situation whereby there are two matters to be concerned. The first matter has to be considered is Bashir made a statement that the car park could only 100 cars, but then found that they could only accommodate 60 cars, and this falls under misrepresentation as there was no evidence that Bashir known the actual number of cars could be accommodated in the car park and as the intention to deceive Abu in entering into the contract. By referring to Section 18, the particular statement made by Bashir could only amount to misrepresentation as Bashir might believe that the car park could actually accommodate 100 cars. Furthermore, by applying the case of Chua Tun Yong and also the case of by applying the case of Chua Tun Yong, the breach did not go to the root of the contract as the space that was sold to Abu in fact a real car park. It was just a matter of fact that the car park could only accommodate a lesser number of cars as represented. So, in conclusion, for the first issue, uh, the fact that Bashir knows the actual situation, his non-closure of the fact towards Abu amounts to a fraud, as the disclosure of such fact could be a major consideration for Abu to decide whether he shall purchase the land. So, for the second issue, is whether Abu can resign the contract between him. Whether Abu can resign the contract. So, the law is Section 19, subsection 1 of Contracts Act, as mentioned that when consent to an agreement is caused by coercion, fraud, or misrepresentation, the agreement is a contract voidable at the option of the party whose consent was caused. An exception under Section 19 was stated that if such consent was caused by misrepresentation, by silence, fraudulent, with the meaning of Section 17, the contract nevertheless is not voidable if the party whose consent was so caused had the means of discovering the truth with ordinary diligence. Also, in the case of Weber and Brown, the plaintiff respondent sued the defendant apparent for damages in respect for alleged false and fraudulent misrepresentation relating to the number of rubber trees of estate over which the latter the right of purchase which right he transferred for valuable concession to the former. So, in the present case, Section 19 allows Abu to resign the contract as his concern was caused by fraud committed by Bashir. However, Bashir might contend under the exception of Section 19 that the rescission of contract should be set aside whereby the purchaser had the means of discovering the truth with ordinary diligence. In this particular case, it will be too unfair for the court to apply the exception of under Section 19 as to inquire about the usage of the land by the government for the purpose of widening the road would require extra diligence which normal purchase would not bother to ask aside the condition of the land. Furthermore, by applying the case of Weber and Brown, it was proved that the exception is not applicable in the case of fraudulent accession, which in this case, Bashir committed fraudulent against Abu for the non-disclosure of fact. Ali is entitled to compensation from Bashir after resigning the contract pursuant to Section 75 of Contracts Act, and also the case of Abdul Rashid, where the assessment of damages should be treated as the contract was being cancelled, in which Abu was entitled to collect all expenses incurred as a result of Bashir's action. In conclusion, the sale and purchase agreement between Abu and Bashir was caused by fraud due to the inactive concealment of fact, and therefore Abu is entitled to resign the contract and claim for damages. Thank you, sir.
All right, thank you, Lashana. Very good attempt. So for the first issue, it fall under section 18 or 17?
18.
18A.
Yeah.
All right. Okay, so class, okay, the first part is when Bashir told Abu that the space could easily accommodate 100 cars if properly placed. After the purchase was concluded, Abu found out that the space is small and could take in 60 cars only. All right. So in my previous tutorial, okay, there were issues whether this should be discussed from the perspective of section 17A. Okay, suggestion as to a fact, the fact suggested is not true made by someone who does not believe in its truth. Okay, the case illustration A in section 19, section 17A was applied in the case of Keng Chui Lian and Wang Tak Tong. Or this should be discussed from the perspective of section 18A. Okay, section 18A, the positive assertion in a manner not warranted by the information of the person making it of that which is not true, though he believe it to be true. Okay, whether this is fraud under section 17A or whether this is misrepresentation under section 18A. Okay, and of course, the distinction between misrep and fraud and what we have discussed, okay, previously is of course the intention to deceive or intention to deceive. All right, so these are the difference between misrep and fraud. When there exists an intention to deceive, then of course it will fall under fraud. When there is none, there is no fraud. There is going to be under misrepresentation. Okay, so from the fact of the case, clearly this cannot be fraud because there is nowhere nowhere we can infer that Bashir had the intention to deceive. So the most appropriate section to go is going to be under section 18A. Okay, the positive assertion in a manner not warranted by the information of the person making it of that which is not true, though he believe it to be true. Okay, and you can discuss all the relevant cases when it comes to misrep. Okay, Abdul Razak bin Dato' Abu Samad and Shah Alam Properties, Simtong Realty and Tekimdar, Chua Tong Yong and KL Golf and Country Club, Olo Kunfat and Pok Klang and Golf Resort, Double Acres Neighborhood and Terrace Estates Neighborhood, Ogumah Kota Enterprise and Public Bank Berhad. Okay, you can discuss to all these cases to establish that this is going to be a misrepresentation. And like I mentioned before that, once you have discussed that, you're going to discuss also whether this would fall under the exception to section 19. Okay, if such consent was caused by misrep or by silent, fraudulent within the meaning of section 17, the contract nevertheless is not voidable if the party whose consent was so caused had the means of discovering the truth with ordinary diligence. So whether or not Abu, okay, should have used his ordinary diligence to first calculate, okay, the amount of card that could be placed, okay, when he first viewed the land or getting to know the size of the land. If that is going to be the case, then of course he will fall under the exception to section 19 by referring to the case of Weber and Brown. So you can argue that there is no, although there is a misrepresentation, it will fall under the exception to section 19. Okay, when the truth can be obtained via the usage of ordinary diligence. Okay, that is for the first one. Now moving on to the second one. 2 weeks later, Abu received a notice from the government that one half of the land would be compulsorily acquired for the widening of the existing road. Bashir did not disclose this matter during the negotiation. Had Abu known this, he would not have concluded the agreement. So, Lakshana suggested that this should be discussed from the perspective of section 17B, the active concealment to effect. Okay, under section 17B, there are two following elements that must be fulfilled. Number one, it must be an active concealment of a fact, and the concealment was made by a person who has knowledge of it, okay, which can be illustrated from illustration C and D to section 19. Okay, and the case to use is the case of Teh Tobok and another and Segar Oil Palm Estate Sendirian Berhad. Okay, the High Court held that, what happened in the case of Teh Tobok, is that when the question was asked to the property agent whether the pipelines and transmission lines form a part of the land, okay, the property agent say that no, it is not. So when the property agent said that the pipeline and transmission line was not part of the land, okay, so that formed as an active concealment. Okay, in order to establish active concealment, there must be question that would ask. Okay, question must be asked. For example, if anywhere in the question stated that Abu asked to Bashir, okay, whether there is any future plan involved with the land, and Bashir said none, for example. If that's the case, then that none would amount to active concealment. Active concealment, okay, must be distinguished from silent. Here from the question, we could not infer that there's been any question asked to Bashir, okay, that would establish the active concealment. Okay, so if we couldn't establish active concealment per the case of Teh Tobok, next thing that we can do is to discuss from the perspective of whether silent amounts to fraud. Okay, and generally under the law, silent is no fraud unless in two certain situations when there exists a duty for the person to speak, and secondly, the silent itself is inequivalent to speech. Okay, the silent itself is equivalent to speech. So coming back to the main issue, okay, it seems that whether Abu can rescind the contract and claim compensation from Bashir, okay, the answer is going to be no. Okay, Abu cannot rescind the contract, no claim compensation from Bashir. Okay, for the first one will fall under the exception to section 19, and the second one, generally fraud silent is not amounted to fraud. Are we clear, Lakshana? Everyone, are we clear on the second question?
Sir, so
Hmm.
if let's say he could establish active concealment, then he can resign and get damages.
Yes. If there is active concealment, if there anywhere in the question stated that Abu asked the question on is there any future planning that is going to involve with the land, and Bashir said none. Okay, in that situation, that none equals to active concealment. To conceal means to say there must be a question asked. Just like the case of Teh Tobok, a question was asked whether the pipeline and the transmission line form a part of the land. The property agent said no, it did not. So that amounts to active concealment. To conceal something, there must be a question. If there is no question asked, so it will fall under the whether silent amounts to fraud.
Okay, sir, clear. Thank you.
Clear? All right, welcome. Okay, so moving on, the third question, mere silent as to facts likely to affect the willingness of a person to enter into a contract is not fraud. Discuss. So in relation to the question that we did just now, whether silent amounts to fraud. Anyone would like to try and attempt the third question, please? Anyone? No one? All right, call out names, yeah. Uh, Lim Desmond. Desmond, third question, please. Hi. Why? Oh, it's been 2 weeks, man. All right, okay. Call. Can I call for Nalal then? Nalal, can you try and attempt the third question, please?
Yes, sir.
Thank you, Nalal.
So 1 minute, sir.
Sure, sure. I
Okay.
mean, it's provided in the slide as well.
Yeah. Okay. So fraud mentioned under Section 17 of Contracts Act provided that active concealment of fact and the concealment that was made by a person who has acknowledged of it amounts to a fraud. In the case of Thai Tuk Bon and Sagar Oil Palm Estate, the plaintiff and the defendant reached an agreement with the plaintiff to buy 11 parcels of the land from the defendant. The plaintiff discovered that portion of the land was being used by the Public Utilities Board for water pipeline and by the Tenaga Nasional Berhad for the transmission cable after paying a deposit and signing the agreement. The plaintiff claimed that the purchase price should be decreased to the accounts for the encumbrance, and the defendant refused, claiming that they were unaware of any land acquisition by the board and that they did not make any representation that the defendant had dishonestly concealed the material fact from them, leading them to believe that the lines and pipelines were not located on the property in question. The court held that the acts of the defendant amounted to fraud and within the meaning of Section 17, and it was found that as a fact that the defendant knew that existence of the transmission line and the pipeline on the said pipeline prior to the signing of the land and the purchase agreement. The court then found that there was such concealment of the existence of the pipeline as the defense agent had informed that the plaintiff that the pipeline did not exist. And nevertheless, in regards of Section 17, subsection B, although it was mentioned that an active concealment amounts to fraud, but in fact, mere silence cannot be regarded as a fraud, subject to certain exceptions. The expansion of Section 17 has been provided that the mere silence as to the facts likely to affect the willingness of a person to enter into an agreement is not fraud, unless the circumstances of the case are such that regard being had to them, regard being had to them, it is duty of the person keeping silence to speak, or unless silence amount to a speech. In the case of Lai Hia and Cargill Engineering, the appellant entered into a hire purchase agreement with the first respondent as a dealer and the second respondent as the owner to take a loader on hire purchase as a hirer. The first response provided him with a 6 months return warranty against faulty parts and the delivery of the spare parts. When the machine was put on work, it developed faults and necessitating the repairs and the replacement of several sections. The appellant claimed that he was duped into signing into a hire purchase agreement by deceptive misrepresentation and that he attempted to withdraw the contract of sale. So the court held that the first respondent did not go out with his way to advise the appellant of the machines of the manufacturer or the knowledge that it had been involved in a small accident during a previous display. So these two factors were not substantial in the same sense that non-disclosure was not intended to deceive or persuade the appellant to enter into a hire purchase agreement. As a result, it can be seen that even though silence amount to fraud, but it will be the other way around if the party silence is under a duty to speak. That's all.
All right, Nala. Okay, mere silence as to the fact likely to affect the willingness of a person to enter into a contract is not fraud. Okay, so of course, the distinction is that the different, like the case of Tetobo and Singapore Palm Oil Plantation, the main requirement under active concealment is that there must be question asked and the question was not being answered truthfully. That is going to be an active concealment. But mere silence, okay, for example, if you are purchasing a new car, a used car from, for example, Carousel or Muda or whatever it is, okay, nowhere in the advertisement is stated that the car, the status of the car, whether the car is accident free or not, for example. Okay, under general rule, mere silence does not amount to fraud. The seller need not to disclose anything other than those which already been listed. Okay, unless into different situation. The two exception to the rule that mere silence is not fraud. There are two exceptions. The first one, when there is duty, there exists duty for the seller to speak. Okay, for example, you ask the seller, I'm interested in purchasing this car. Has this car met with an accident before? So in that situation, okay, you put the duty for the seller to speak. Okay, failure on his part to speak or to reveal the accident history of the car would amount to fraud. That is the first one. And the second one, okay, when the silence itself is equivalent to speech. So instead of asking the seller on the history of the accident of the car, okay, you tell the seller, if I hear nothing more from you, then I would assume that this car is accident free. So by doing so, you are putting the duty to the seller. If he knows, if he kept being silent, then you're going to assume that the car is accident free. If a car has met with an accident before, then it would equivalent to fraud. So generally, under section 17, mere silence is not fraud unless under the two exceptions. We clear, class? For the third question, all right, thank you. Okay, moving on the last question, under the last question for fraud and mistrap, ya, bukan the last question for the day. Okay, the last question for fraud and mistrap. In the case of Ang Hyok Seng or Ang Yok Seng and Yim Yut Kyu, counsel for the appellant has referred to various authorities which seem to establish the proposition that the criminal burden is applicable to every allegation of fraud. But it must be noted that the majority of the leading authorities on the subject were dealing with criminal fraud in civil proceedings. With the help of decided cases, explain the burden of proof required in cases of fraud in civil proceedings. So this question is asking you on the discussion on the standard of proof, burden of proof required in fraud in civil proceeding. Can I call for Shabil? Shabil, can you try and discuss the fourth question? Is available in the slide as well, would it not? Shabil? AFK. Alright, Shabil is...
Sir, can I try, sir?
Yes, Joel. Thank you so much, Joel.
All right, thank you, sir. Okay, so the law demands a high standard of proof in cases where there is an allegation of fraud. There is, however, some uncertainty in the standard required where the fraud alleged in civil proceedings is purely civil in nature. In the former federal court case of Lau Hee Tia and Hargill Engineering, Sendirian Berhad, Abdul Kader J held that when fraud is alleged, the standard required in civil cases is proof on a balance of probabilities, but the degree of probability required will vary from case to case according to the gravity of the allegation. A civil court, when considering a charge of fraud, will naturally require for itself a higher degree of probability than that which it would require for the tort of negligence. It does not adopt so high a degree as a criminal court, but still it does require a degree of probability that commensurate with the occasion. Therefore, the more serious the allegation of civil fraud, the higher it would be the degree of probability required. Simply put, it is higher than on a balance of probabilities, but lower than the standard of beyond reasonable doubt. The federal court in the case of An Hyok Seng and Yim Kut Kyu also stated that where the fraud alleged in civil proceedings is purely civil in nature and not based on a criminal conduct or offense, the civil burden of proof on the balance of probabilities is applicable. In the Supreme Court case of Chu Chun Moy and Gan Siu Tin, it had earlier expressed the same view as follows, that fraud, whether made in civil or criminal proceeding, must be proved beyond reasonable doubt and cannot be based on suspicion and conjecture. Proof beyond reasonable doubt does not mean proof beyond the shadow of doubt. The degree of proof need not reach certainty, but it must carry a high degree of probability. What it means is that the evidence adduced is such that the court or prudent man considers its existence probable in the circumstances of the nature. However, on the contrary, another panel of the federal court judges in the case of Yong Tim and Hock Hock Chong, without referring to the case of Ang Hyok Seng, said, and the Supreme Court case of Chu Chun Moy and Ngan Siu Tin held that the standard of proof required where there is an allegation of fraud in civil proceedings must be one of beyond reasonable doubt and not on the balance of probabilities. Hence, the lack of reference by the federal court in Yong Tim and Hu Kok Chong to the two previous decisions of the highest courts in Malaysia was pointed out by the Court of Appeal in the case of Lembaga Kemajuan Tanah Persekutuan and Awang So bin Mahmad. So the federal court's decision in Yong Tim and Ho Kok Chong was applied by another bench of the federal court in ASEAN Securities Paper Mills and CGU Insurance Sdn Berhad, where Nick Hashim, federal court judge, observed that it is now settled law that the standard of proof required where there is an allegation of fraud in civil proceedings must be one of beyond reasonable doubt and not on a balance of probabilities. That is all, sir.
All right. Thank you so much. Okay, so class, to answer this question, right? To answer this question, to explain the burden of proof required in cases of fraud in civil proceeding, this question cannot be answered simply by discussing one or two cases. It must come from various cases discussion. Okay, for example, Datin Zainul binti Ismail Tuan Minah bin Syed Azman, the case of Gopal Al-Krishna and Syed Azman and Sheikh Muhammad, and of course, the decision by Justice Abdul Qadir, Court Justice in the case of Lauhita and Harga Engineering, proof of fraud in civil lies on its balance of probabilities, but the degree of probability will vary from case to case according to the gravity of the allegation sought. Okay? A civil court, when considering charge of fraud, will naturally require itself a higher degree of probability than that which it would require when asking if negligence is established. It does not adopt so highly a degree as criminal court, but still does require a degree of probability which is commensurate with the occasion. So Justice Abdul Qadir, argue that the burden of proof for fraud in civil cases is degree of is balance of probabilities, but with a higher degree. Okay, and this can be discussed, can be distinguished from the decision of other court. Okay, for example, in the case of Datuk Jaginda Singh and others, Antara Raja Ratnam, in which the private counsel held that the learned trial judge and also the federal court correctly directed themselves to the standard of proof in civil proceeding, and that was the criminal standard of proof beyond a reasonable doubt, and can also be which was adopted as well in the case of Saminathan and Papa, and the case of Chu Chun Mui and Ngan Siu Tin, okay, which also of the opinion that proof beyond a reasonable doubt does not mean proof beyond the shadow of doubt. The degree of proof need not reach certainty, but it must carry a high degree of probability. So coming back to the question, okay, so you're going to come with you can say, as can be seen from cases from case Chu Chun Mui and Ngan Siu Tin, clearly the similarities between the decision of Justice Abdul Qadir is there. All right, are we clear, class, for the last question? All right. Okay, that is going to be the first question. Now let's move on to the mistake part. All right, for mistake also we have 4 questions. The first one is easy. Okay, to discuss all these 3 cases which we have discussed during the lecture. Okay, second one, to discuss these 2 cases, Kandi and Lindsay and Philip and Brooks, the difference between inter-absentees and inter-presentees. Third question, to discuss the case of Coutier and Hasty and Strickland and Turner. Okay, and the last one is situational question as well. So we start straight away, yeah? Can we, class? Okay, all right. The first case, okay, the first question, read the following cases: the case of Bell and Lever Brothers Limited, Shui Brothers Limited and Ochsner, and Okham Others and Tam Kong. Okay, and explain briefly the fact in these cases and the applicable law, and to discuss how relevant statutory provision on mistake in Contract Act could be applied accordingly. So either section 21, 22, or 23 of the Contract Act. Anyone would like to try and answer the first question, class? Emilia, thank you so much, Emilia.
Sir, am I audible?
Yes, you are loud and clear.
Okay, I'll begin with the first case, Bell and Level Brothers Limited. The fact of the case, Mr. Bell was the managing director for 5 years of a company that was owned by Level Brothers Limited. Mr. Bell had traded for personal profit during his employment, which was contrary to his contract with the company. Without knowledge of this, Level Brothers Limited made an offer of redundancy to Mr. Bell, terminating his contract and offering a 30,000 crowns payment as compensation. The main issue in this case was whether the redundancy contract that was created and accepted by Mr. Bell could be void by a common mistake due to later finding out about his personal trading. Level Brothers Limited argued that this concealment and misconduct was a breach of his duty that was detailed in his employment contract. The court held that the contract was not void as the mistake was not an essential and integral part of the contract. The personal trading that had happened during the employment was not related to the subject matter of the contract and was said to be minor compared to the profits Mr. Bell had made for Level Brothers Limited. Only a mistake to the identity of the parties or of subject matter to the contract, as well as an item's quality, would be able to successfully negate consent and therefore void a contract as if it had never existed. The mistake must be essential to the identity of the contract. According to Contract Act 1950, the decision of this case seems relevant to Section 31 of Contract Act, where both the parties to an agreement are under a mistake as to a matter of fact essential to the agreement. The agreement is void. An erroneous opinion as to the value of the thing which forms the subject matter of the agreement is not to be deemed a mistake as to a matter of fact. In the above case, although there was an element of mistake in the agreement, it was not such as to invalidate it. The mistake was not operative. The company's claim failed. The 3-2 majority of the law lords observed that the action failed because the alleged mutual mistake alleged was not related to the subject matter but to the quality of the service agreement. Sir, do I need to discuss the second case?
Yes, all the cases, please.
Okay.
Thank
For the
you.
second case, Share Brothers Limited and Oshner. In the case of Share Brothers Limited and Oshner, the parties had entered a contract which obliged the respondent to acquire the manufacture all sisal flooring on 5,000 acres of land in Kenya. The respondent was required to deliver to the appellant 50 tons of sisal fiber for sale per month. However, the respondent was unable to do so as the lift potential of the sisal was insufficient to produce so much monthly. The question before the court was whether the mistake as to the possibility of performing the contract renders the contract void. The court held that there was a mistake as to a matter of fact essential to the contract and thus the contract was void. Mistake as to the possibility of performance of the contract. Mutual mistake of fact as both parties believe contract to the fact that the lift potential of the sisal area would be sufficient to produce the stipulated minimum quantities. The public counsel held that the mistake was a matter of fact essential to the agreement. According to Contract Act 1950, the decision of this case seemed relevant to Section 31 of Contract Act, where both the parties to an agreement are under a mistake as to a matter of fact essential to the agreement. The agreement is void. So, moving on to the third case, which is Ohayam and others and Tamkong, rectification of a written contract. In the case of Ohayam and Tamkong, the parties agreed to purchase and sell of certain land in Gombak only. However, when the contract was put into writing, the contract also included a land in Setapak. The written contract was set aside by the court as the parties did not intend to include the land in Setapak. More importantly, the mistake was not made at the time of entering into the contract, but was made when the contract was put into writing. Hence, it was not void under Section 31 of Contract Act 1950. Mistake in inclusion of a property in the other property, so non-intentional inclusion of a property amongst the properties, so was held to have been made under a mutual mistake between the contracting parties. Ratification of the contract was ordered. That's all, sir.
All right, thank you so much. Okay, so class, we can see that for the first case, the case of Bell and Lever Brothers Limited. Okay, Bell was working with a company owned by Lever Brothers, was found guilty of trading for his own profit. Okay, so because of that, he was offered a redundancy contract. Okay, redundancy contract is actually a way of dismissal by which the company is telling you that your position is now redundant. Okay, and together with that redundancy contract, the company agreed to pay him 30,000 pound. Okay, and he has signed the contract. Okay, and would like to challenge the validity of that redundancy contract signed. So this case was was held by the court that the mistake, okay, committed by Bell was only a minor one. Okay, plus he had brought in more profit compared to the uh, profit that he had done on his own, and therefore this mistake was a mistake as a matter not essential to the agreement. So it will fall under Section 21 because Section 21 discuss mistake as to a matter of fact essential to the agreement. And in the case of Bell and Brothers, Level Brothers, it was held that this mistake was not essential to the agreement. Therefore, the contract, okay, the redundancy contract was held to be void. The first one. The second one is the case of Sheikh Brothers Limited and Oshner, in which this discuss about the suitability or no this case discussed about the production of sisal fiber, okay, in which there were required number that need to be produced monthly, okay, with around the 5,000 areas of land provided in Kenya. But it was held that with the amount of the land provided, okay, it is impossible for the supplier for the supplier to commit to produce that amount of sisal fiber. Okay, because this is an appeal from Eastern Africa. Okay, the appellant company granted license to A, okay, which was later assigned to respondent to cut and manufacture all sisal fiber growing on 5,000 acres of land in Kenya. The respondent was to deliver the appellant 50 ton of sisal fiber per month. The respondent was unable to do so as the leaf potential of the sisal fiber was insufficient to produce that much monthly. So this would fall under under the mistake as to the possibility of performing the agreement, okay, which is also provided for under Section 21 of Contract Act 1950. And the third case, the case of Ohiam and others and Tamkong, okay, the both parties have agreed verbally over the sale and purchase of land in Gombak. Okay, so on the fact of the verbal contract, nothing is wrong, everything is okay. The problem occurs when the contract is being put into writing. Why? Instead of focusing only on the sale and purchase of the land in Gombak, it also included a land in Setapak. Okay, so the question that arises whether this would fall under the application of Section 21, okay, where both parties to an agreement are under a mistake as to the matter of fact essential to the agreement is void. It was held by the court that this is not a mistake under Section 21. Why? Because the mistake occurs after only when the contract is being put into writing, not at the formation of the contract, not at the time when both parties are concluding the contract. The mistake only occurred when the verbal contract was being put into writing. So what did the court do is to rectify the situation by removing, okay, the transfer of land in Setapak. So the contract is not void. Are we clear, class, for the first question? All right, thank you. Okay, second question. In the case of Kandi and Lindsay, the parties' purported contract was entered into inter absentis, whilst in the case of Philip and Brooks, the dealing between the parties was done inter presentis. In this unilateral mistake situation, the court have decided different rule have to be applied in each situation. Discuss the ruling in these cases with reference to Section 23. Okay, Section 23, contract caused by mistake of one party as to matter of fact. Anyone would like to try and have a go at the second question? Last? Anyone? No one? Okay, I'll call up names, yeah. Yung paying, can you try and discuss the second question?
Oh, sorry, sir, I didn't prepare this question.
You don't prepare. All right. Okay. Ziahao, can you try?
I won't do that, sir.
Ayo, a while, eh? It's been 2 weeks, way. All right. So this case, Kandi and Lindsay and Philip and Brooks, okay, both discuss on unilateral mistake. What happened in the case of Kandi and Lindsay, okay, as you can see from the slide, okay, is that Kandi intended to sell the handkerchief to a reputable company, Blankiran. Okay, but instead the actual purchaser was Blanken. Okay, so there is a unilateral mistake on Kandi and Lindsay. Okay, because the plaintiff did not intend to deal with the buyer Blanken, but with Blankiran and Company. So when the Blanken had obtained the handkerchief, the Blanken then has disposed of those handkerchief by selling it to Lindsay without even paying Kandi. So the question here was whether Lindsay, being the bona fide third-party purchaser, had obtained a good title over the goods. Okay, that is the first case. Okay, let us discuss the fact of the case first. Second case is the case of Philip and Brooks. Okay, Philip and Brooks, on the other hand, also discuss the situation of unilateral mistake. But what happened in this case is that the plaintiff, Phillips, okay, is actually a jeweler, okay, who was being played, okay, by a fraudster. The fraudster had signed the name of Sir George Bolo, okay, and even the plaintiff went on to allow the fraudster to collect the ring without payment. Okay, so the fraudster has come, collected the ring without payment, and after that disposed it off by selling it to the Brooks Limited. So the same question was asked whether Brooks, being a bona fide third-party purchaser, had obtained a good title. Okay, so the only difference between Kandi and Lindsay and Philip and Brooks is that in Kandi and Lindsay, the contract was entered into inter absentis. What does it mean, inter absentis? Inter absentis refer to the fact that the contract was concluded without the appearance of both parties. Whereas in the case of Philip and Brooks Limited, the contract was entered into inter presentis. Inter presentis means to say that when the contract was concluded, both parties were present. Okay, both parties were present. So it was held by the court that when the contract was entered into inter presentis, when both parties were present, there exists a chance for the seller to inspect for any mistake. Okay, inspection for any mistake can be done when the contract is being entered into inter presentis. And as such, because the contract was entered into inter presentis, okay, Brooks Limited, being the third party bona fide purchaser, had a good title over the ring, as opposed to the case of Kandi and Lindsay. Okay, since the contract was entered into inter absentis, hence there was no chance for the seller to inspect for any mistake. Therefore, Lindsay did not obtain a good title despite being the third party bona fide purchaser. Are we clear, class? The difference between inter absentis and inter presentis. When there exists a chance for the seller to make inspection to ensure that there is no mistake, then the subsequent third party bona fide purchaser would obtain a good title. When the contract was entered into inter absentis, okay, with no chance for the seller to inspect for any mistake, then subsequent buyer, be it a third party bona fide purchaser, cannot obtain a good title over the goods. Clear? Oh, class. Right, so that is the difference between inter presentis, inter absentis. And the inter presentis, the third party bona fide purchaser will obtain a good title. Why? The seller has had chance to make inspection. And the inter presentis, okay, even the third party, even bona fide purchaser will not obtain a good title. Why? Because the seller has not had the chance to make the inspection. All right, moving on to the third question. The case of Kocher and Hasty and Strickland and Turner, both cases are available in the slides. Anyone would like to try and discuss these cases? Karin Ng, Karin, can you please try and discuss these two cases?
Okay, sir.
Thank you.
So in the case of Couturier and Hasty, the plaintiffs were merchants at Smyrna. They brought an action against the defendant, Hasty, who sold on the Credier commission a cargo of corn to a buyer. The corn was described as of average quality when shipped, and the price including freight and insurance to a safe port in the United Kingdom. Before the date of the sale of the corn had been unloaded and sold at Tunis, owing to it having become so heated during the voyage of Salonika, the buyer, on hearing this, repudiated the contract, and Hasty was sued by his principal for the price. The trial judge ruled that at the time of the contract, the corn was in existence and capable of delivery, and that the action of the plaintiff fell. The House of Lords held that at the date of the contract, the parties contemplated that there was in existence a cargo to be bought and sold, but in fact at that date there was no such cargo. Therefore, the buyer was entitled to repudiate the contract. Consequently, the principal's action against Hasty fell. Lord Cranworth said, looking to the contract itself alone, it appears to me clearly that what the parties contemplated, those who bought and those who sold, was that there was an existing something to be sold and bought. The contract plainly imports that there was something which was to be sold at the time of the contract and something to be purchased. No such thing existing, I think the Court of Exchequer Chamber has come to the only reasonable conclusion upon it, and consequently that there must be judgment for the defendants. Under this fits under illustration A of section 21 of CA, as illustration A states that A agrees to sell B a specific cargo of goods supposed to be on its way from England to Kelang. It turns out that before the day of the bargain, the ship conveying the cargo had been cast away and the goods lost. Neither party was aware of the facts, and the agreement is void. So for the case of Strickland and Turner, Lane, the deceased, was entitled for his life to an annuity of £100 per annum, payable half yearly in March and September. It was bequeathed to him under the will of Mrs. Bray. The plaintiff was the executor of Mrs. Bray. On 4th June 1847, Lane, then in Sydney, transferred the annuity to Daintree, who was in England, to dispose of as his trustee and for his benefit. In November 1847, a correspondence was entered into between Daintree and the agent of the plaintiff, as the plaintiff wanted to purchase the annuity. On 28 February 1849, only then by indenture between Daintree and the plaintiff, the purchase of the annuity was executed. On 6 February 1849, before the indenture was executed, Lane died. The issue was whether the plaintiff was entitled to recover from the defendant, executrix of Lane, the sum paid for the purchase of the annuity. It was held that the plaintiff was not entitled to recover because when the plaintiff purchased the annuity upon the life of Lane and unknown to the parties, Lane, the annuitant, was already dead. The purchase was not settled in the lifetime of the annuitant. In that case, the contract for sale of an annuity was held to be void at law, and the money was ordered to be repaid on its being discovered that the person on whose life an annuity depended had, without the knowledge of either party, died before the date of the contract of sale. The parties were treated as having intended to contract on the basis of something of value actually existing, and as this proved not to have been the case, the contract failed to be binding. In the Malaysian context, this case is similar to illustration C of section 21. This is a case of common mistake. The illustration states A, being entitled to an estate for the life of B, agrees to sell it to C. B was that at the time of the agreement, but both parties were ignorant of the fact the agreement is void. That's all for the case.
All right, thank you so much. Okay, Karen, very good discussion. So the case of Koche and Hesty and Strickland and Turner discuss on the issue as to the mistake as to the existence of subject matter. Okay, mistake as to the existence to the subject matter. Why? Okay, in both cases, okay, the subject matter ceased to exist before the agreement is entered. Okay, and it would fall under section 21. Okay, why? Because the existence of subject matter is the underlying assumption of the agreement. It was matter of fact essential or fundamental to the agreement. So in the case of Koche and Hesty, about the sale and purchase of a container of corn is selling to London, which turned out to be lost at sea, okay, before the contract was even concluded. So when the seller, okay, insisted the purchaser to pay for the purchase price with the underlying understanding that the purchaser will have to bear the risk of the goods being lost at sea, okay, the court held that the issue of the mistake as a fact, okay, as to the fact essential to the agreement. Why? Because the container, okay, the vessel, the cargo, okay, was lost at sea prior to the conclusion of the agreement. So the subject matter ceased to exist before the agreement is concluded. It can be fitted under illustration A to section 21. A agrees to sell B specific cargo of goods supposed to be on its way from England to Klang. It turns out that before the day of the bargain, the ship conveying the cargo had been cast away and the goods lost. Neither party was aware of the fact. The agreement is void. Or illustration B, A agrees to buy from B a certain horse. It turned out that the horse was dead at the time of the bargain. Though neither party was aware of the fact, the agreement is void. So when the subject matter ceased to exist prior to the conclusion of the agreement is void. And whereas in the case of Strickland and Turner, okay, where both parties entered into the life assurance, okay, when both parties when the plaintiff entered into life assurance of Turner, which turned out to be dead at the time of entering into the agreement. So the question, the issue was whether the plaintiff could obtain the payment of premium back, okay, in which the same ruling was adopted. When the subject matter ceased to exist prior to the conclusion of the agreement is void. And this can be discussed from the perspective of illustration C to section 21. A, being entitled to an estate for life of B, agrees to sell it to C. B was dead at the time of the agreement, but both parties were ignorant of the fact the agreement is void. Right? Are we clear, class, on the question 3? All right. And the last question for the day. Dola and Mamat are two good friends. They are wristwatch enthusiasts. They both particularly adore the Breitling watches as they are 100% Swiss made and their timepieces are chronometer certified, which is unique to the brand. Dola offered to sell to Mamat his used Breitling Navitimer 01 wristwatch for 120,000. Mamat agreed to buy. Mamat then transmitted 120,000 to Dola's bank account. On the delivery of the wristwatch, it turned out to be a Breitling Navitimer 01 46mm, which is smaller in size and would cost 90,000, much less than the price paid for. Mamat brought an action against Dola due to a mistake of fact. The contract was void and wished to claim back the money paid. Dola, however, argued that it was just a mere mistake as to the quality and would not render the contract void, advised Mamat. Alright, so in this case, the issue was whether Mamat can brought an action against Dola due to mistake of fact. Okay. So you're going to discuss this issue because because Dola offered to sell Mamat his used Breitling Navitimer 01. Okay, but it turned out to be Breitling Navitimer 01 46mm. The size, okay, 46mm refer to the size of the face of the dial. Okay, so 46mm is the smaller version. Maybe they have 50mm, which is the larger version. So you're going to discuss whether this is a mistake of fact or whether this should be mistake of fact under section 21, as can be seen, okay, from the case of Sheikh Brothers and Ochner, which private counsel has further elaborated. This mistake of fact come under 4 conditions. The first one, mistake as to the distance, mistake as to the identity, mistake as to the quality, or mistake as to the possibility of performing the agreement. Clearly, mistake as to the distance or mistake as to the possibility is not it. It is either mistake as to the identity or mistake as to the quality, or whether this would fall under section 23, a unilateral mistake. Okay, so you're going to discuss that. Okay, and then conclude whether Mamat can claim, okay, we can take action against Dola under mistake of fact. Okay, personally, if you're going to see that this is going to be mistake as to the identity, Dola offered to Mamat to sell his used Breitling Navitimer 01. Okay, and Mamat was given Breitling Navitimer 01. So I don't believe this is going to be identity. Identity is when one party intend to deal with one thing, and the other party thought it was another thing. So that is going to be mistake of identity. Okay. Clearly, the topic of the dealing is Navitimer 01, which was true. So it's not going to be identity. So it is either mistake as to the quality or unilateral mistake. In other situation, the contract is not void. Are we clear, class? So I've answered the question for you. Any other question that you have for the last part, the last discussion? Any question? So, sir, if different in color, size falls under quality. Yes. It's depending. Shika, it depends on the advertisement. For example, in this case, okay, Dola offered to sell Mamat his used Breitling Navitimer 01. And Mamat was given a Breitling Navitimer 01. Right? So unless the advertisement, the topic of the sale, for example, is Navitimer 01 46mm, Navitimer 01 50mm, but Mamat was given Navitimer 01 46mm. In that situation, then yes, Okay, is going to be identity. It can be discussed from either identity or quality. Okay, but in this situation, since the offer by Lola is only Navy Timer, Breadlink Navy Timer 01, and Mamat was given a Breadlink Navy Timer 01. So that couldn't be an identity. All right. All right. So now is attendance taking time. Okay, it's going to be a bit lengthy, so please bear with me. Curriculum management, attendance by class. So as discussed earlier, can you please raise your hand if you're from T5 first? Let's take the attendance from T5 first. Right, T5 sir. Okay, please maintain, raise your hand until I ask you to lower your hand. Because this is going to be a bit time consuming. T5. This is for week 6 and week 7, right? Okay. All right, so now T5 can lower your hand. Okay, T3, can you please raise your hand? All right, it's time for T3. Okay, T5, please lower your hand. Sini Jerry. Jerry. Just me clearing Daniel. Wait, there are certain names missing from T3. So let me generate the latest attendance first. Okay, all right. Wait, T3.